Delegate from Frederick, Delegate Collins.
Thank you, Mr. Speaker. I rise for a point of personal privilege.
Delegate has the floor.
Thank you, Mr. Speaker. Ladies and gentlemen of this body, as you all know, I'm adopted through the Catholic Charities. And this most recent discussion we've had the last couple of weeks over abortion has been very difficult and very trying for me as I go through my own emotions of my own upbringing. And although there are many other legal reasons why I do not support the ERA or the rules changes that are being argued here before us today, I think it's important to hear directly from those courts which Delegate Garrett referenced yesterday. The record of court cases involving the Equal Rights Amendment is clear. Whether anybody in this body likes it or not, the Equal Rights Amendment will be used to eliminate those bipartisan protections that we have put into place. Let me quote directly from one of the cases Delegate Garrett cited yesterday, and this is from the Connecticut Supreme Court in Doe v. Mayer. The court concludes that the regulation that restricts the funding for medically necessary abortions except when the woman's life is endangered violates the Equal Protection Clause of the Constitution of the State of Connecticut, and more specifically, Connecticut's Equal Rights Amendment. From the words of the New Mexico Supreme Court, New Mexico Right to Choose NARAL versus Johnson, based on the independent grounds provided by the Equal Rights Amendment to Article 2, Section 18 of the New Mexico Constitution, we affirm the district court's order granting plaintiff's motion for summary judgment, permanently enjoining the department from enforcing its May 1995 revision of Rule 766 and awarding costs to plaintiff. And let me quote as well, Mr. Speaker, from the words of the Alaska Supreme Court, which just this past Friday, in a case regarding, again, taxpayer funding for abortion, the Alaska Supreme Court said, the statutes and the regulations factually different treatment of pregnant women based upon their exercise of reproductive choice requires us to apply strict scrutiny, and the proposed justifications for the funding restrictions do not withstand such exacting examination. We therefore conclude that the statute and the regulation violate the Alaska Constitution's guarantee of equal protection. Mr. Speaker, late-term abortions, especially where a child, like myself, like Delegate Brewer, are viable but can still be aborted, Mr. Speaker, I just cannot support it. That is why this is not about equality, but it's what the ER is about, and I hope this body will reject the rule change. Thank you, Mr. Speaker.